You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Or at least welcome this week to Ask a Lawyer here on CP24. We are back to fill your head with knowledge, educate you about employee rights, workplace rights, and employment laws. That's what we do. John Scholes, your host here every week, and joining me, employment lawyer again, Lior Samfiru. You want to reach any time to Lior outside the half hour of the show. You're always encouraged to do so, right? 1-855-821-5900, the number. It is ask@employmentlawyer.ca, and the website anytime. We'll talk about it. It'll come up over the next half hour. That, I guarantee you, would be pocketemploymentlawyer.ca. All kinds of ground to cover over the next 30, including rights of an aging employee in an aging workforce. We'll get to that. If you're part of that group, maybe that's a personal slight. I don't know. We'll talk to Lior a little bit about that one. I'm not sure, but there you go. That's all coming up. We'll get to some phone calls from one of our radio shows. By the way, you can tune in and join into our radio show weekly, especially here in the GTA News Talk, 1010 Sundays at 1 p.m. Would love to have you join us there as well. That's all coming up, Lior, but we always start off with a story. Maybe a week that was something cooking on your end, pal. What do you got?
It's okay, John. We won't get rid of you because of your age, I promise. We won't do that. We thought about it, but we won't.
Did.
So thank you, John, and welcome everyone to this show where you learn about employment law, where you get to find out about your legal rights and hopefully become more educated about this very, very important topic. It's not always that things are going to be great in the workplace. Sometimes they are, but other times there's issues, there's problems, there's dilemmas, and on this show we'll tell you what you need to know if you're facing one of those workplace problems. Maybe you lost your job. Maybe your boss is doing something that's inappropriate. Maybe you've been given a warning or you've been written up and you want to know what to do about it. Well, we'll talk about these topics every show. And of course, if you want to continue that conversation, if you have a private chat with me and my team, the contact information is on the screen. We'll keep giving it to you. Reach out. Don't be bashful. We can have that conversation. But I always like to start off with the situation that came across my desk. I spoke with an employer an employee, I should say, who found out that his employer was selling the business. But he got news from the new company that says, good news, we're going to offer employment to you and to everyone else. You're going to have employment offers, but we need you to fill out this form confirming that you're going to be accepting this offer. We'll give you the offers at a later date, but for now, confirm that you're going to accept the offer. And if you don't sign this form by a certain date, we'll consider you to have resigned. Well, wait a second. This person calls me and he asks me a very legitimate question. I haven't seen the offer. I don't know what the title is, what the role, what the hours, what the pay are, but they want me to accept it or else I've resigned. What's going on here? Well, he's absolutely right to be wondering that, because you can't be told to accept or reject an offer, a new role, unless you have all the particulars. You need to know what you're accepting, what the job is going to be, what the terms of employment are. So what I told them in this situation is to say, no, I can't accept or reject because I don't know what you're offering me. Once you've given me the offer, I'll review it and I'll tell you yes or no. Well, this company, I said, if they say, no, you've resigned because of that, well, that becomes a termination. It's going to be very expensive to terminate this individual. He'd been there for 20 years. He'd be looking potentially at as much as 24 months of severance. So he's now responding to the company and seeing what they do. But I wanted to remind all of you there, whether it's in a sale of a business situation or in any other setting, if you're being offered a job and asked to accept it or deny it, you have to have the terms of the offer to have a meaningful discussion, to have a meaningful response back to the company. It can't be some vague thing. And if your company is not happy with that and they let you go because of it, there's going to be consequences. Any issues, any problems, you give me a call.
And I guess, Lior, even if this company decides to wise up and hand him the employment contract before him signing it, that doesn't mean he's going to be free and clear. There could be things, and chances are there will be things in there he doesn't want to agree to, right?
Well, that's probably where the interesting issues begin. Just because they've given them the offer doesn't mean the offer is adequate. There could be very problematic terms in there, like something that limits his future severance, cost him tens of thousands of dollars, terms that allows the company to put him on a temporary layoff or to change his pay, to change his hours. So yeah, we need to review that properly, but we can't even do that until we have the offer before us.
EmploymentLawyer.ca, the website you want to go to, the media page, find a radio station pretty much across the country that carries our radio show every week, if not every day during the week, including right here Sundays, 1 p.m. on our brother station News Talk 1010. I mentioned getting some phone calls from radio show. Talk about them here. Lior, first phone call's coming up right now.
I am on a long-term disability. I'm getting ready to go back to work. However, it looks like the position that I was employed at before, about 15 years, no longer exists. I wonder if they are obligated to put me into a different position, or most likely will I be getting a package? I'm 46.
So when you come back from a disability leave, the company has to make all efforts to bring you back to the same job. Now, if that job doesn't exist, it stopped existing, well, then they have to make all efforts to find you a similar role. If they've tried and they can't, there just isn't, maybe it's a very small company, there's just not a similar role, then they can let you go with severance. Or maybe they find a role for you, but it's very different. It's not the same role, it's different responsibilities, different pay, different hours. Well, you as an employee don't have to accept it, and you're still owed severance in that situation. So they have to make the efforts to bring you back from a disability leave. If there's no job legitimately, they've tried, but there isn't a job, then we're talking about severance. So the question then becomes, how much severance is she owed in this particular situation? Well, we're going to do what we like to do on the show. We're going to go to pocketemploymentlawyer.ca. We're going to use our severance calculator tool so that you can see and I can show you how much severance she's owed. So she's 46 years of age as a supervisor. We don't know yet if the company is going to offer her severance, but we see that she's owed right around 16 months of severance, and that could even be more than that, but right around 16 months of severance. That's why it's so important to use the severance calculator. It's free and anonymous. And remember, of course, that you do have a right to be considered for a job when coming back from a disability leave.
All right, good stuff. Good start, Lior. We'll take a short break. On the other side, rights of older employees in an aging workforce. That's coming up just ahead right here on Ask a Lawyer on CP24. Don't go anywhere.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Okay, welcome back. This is Ask a Lawyer here on CP24. John Scholes here. Joining me, Lior Samfiru, employment lawyer from EmploymentLawyer.ca. Reaching out, always give you that contact information. Use it on your own time, anytime. 1-855-821-5900. Ask at EmploymentLawyer.ca would be the email address. Lior, always have a main topic every week on the show. The one for this week is rights of older employees in an aging workforce. First question is this. Can an employer simply fire somebody who's older simply because of their age? No other reason.
So the law here, John, is very clear, and there's really no discretion. An employer cannot consider age when deciding to let an employee go. Now, note what I said. I didn't say that you can't be fired because of your age. That's a given. It's beyond that. Age should not even be a factor, even a consideration when deciding to let you go. So if an employer has 5 reasons to let you go, but one of them even is age, it's already illegal. That's a human rights violation. Just like you can't let someone go because of their disability, because of their gender or sexual orientation, you cannot have age be a factor in any way, shape, or form. And sometimes it's tough to decide if the age was a factor. Other times it could be obvious. If you're one of 50 employees, everyone is younger than you, and you're the only one that was let go, well, it kind of starts to look, right, like age is an issue there, and that may be an illegal termination. And if it is an illegal termination, if it is a human rights violation, in that situation, you could be owed significant damages beyond just the severance. So if you think that's happened to you, if you think your employer is letting you go because of your age, it's illegal, and you got to give me a call.
Lior, if that older employee started to become, a little less productive, can't keep up maybe in the workplace, can that employer discipline them, or can they, suggest, as I know you've come across before, that they maybe resign? How about that?
Well, an employer obviously is allowed to expect that their employees do a good job. And if an employer has an employee that's not doing a good job, that's not productive, that's not meeting the reasonable targets, that employer has to manage that performance. They have to discuss the employee, help them, maybe put them on a performance improvement plan. If necessary, even provide discipline if the employee clearly is just not doing a good job. Now, what an employer cannot do is they cannot tell someone that they should retire because of their age or force them to retire. From the employee standpoint, if your age or maybe your mental condition or health condition is impacting your ability to do your job, you have to tell your employer, and ideally to give them a doctor's note. Because if you're telling them that my performance may be impacted, just so you know, because of my health and I need some accommodation, your employer can't do anything to you in that situation. They can't punish you. Whereas if you don't tell them, your employer may just think you're being lazy, you're not working hard, and you can be disciplined. So don't be upset and don't be shy to provide that doctor's note. But an employer, of course, you cannot just fire someone because of their age or even consider that as a factor.
If it comes, Lior, to the point of severance with that older employee, how does that change the calculation in that whole picture?
So age, the person's age is one of the three big factors that go into deciding how much severance someone gets. So the factors are age, position, and length of employment. So what this means is that the older you are, the more severance you are owed. So a 65-year-old employee, for example, is owed much more severance than a 45-year-old employee, all other factors being equal. So if you're older, and if because of that it may be more difficult to find another job, you're going to be owed that much more severance, and it may be a lot easier to get to that 24-month mark. So frankly, even if you've only worked for a company for a couple of years, but you're an older employee, you could be owed severance that's worth a year. So very important to remember that your age is actually a factor that may significantly increase the amount of severance that you're owed.
All right, good stuff, Lior. As we mentioned and did in the first segment of the show, we talk about our radio shows across the country where we invite you always to tune in and join us locally here in the GTA. That would be News Talk 1010, Sundays at 1 p.m. Phone call number 2 is coming up right now, Lior. Listen up.
I work for a retail company, a large one, and I've just been hearing things. I'm just curious if it's actually true or not. Say, for example, there is a manager that's been with the company for, say, 20 years. Instead of terminating their employment and paying them out to save money, I've heard that they will give them notice to let them go, say, like 9-10 months, your job will no longer be available, and they don't have to pay them out. Does that happen?
And it's a good question. It's a common one and one that I get asked often. So an employer can avoid some, at least, or even all of the severance that it owes if it gives sufficient notice of termination. So if you're owed, as an example, 18-month severance, one way the employer can meet that obligation is to provide you 18 months advance notice of the termination of your employment. They can do that legally. Now, in most cases, employers don't do that. They don't want an employee sticking around once they're being told that they no longer have a job. But in other cases, even if an employer does provide advance notice, in my experience, in most of those cases, they don't give enough notice, sufficient notice, meaning they have to make up that difference in severance. So if you're owed 18 months notice or severance, but you only get 10 months notice, well, that 8 months, the remaining 8 months have to be made up by way of severance. So if you're let go with notice, without notice, with severance, without severance, whatever the situation is, you give me a call and you give me a call right away.
That was phone call number 2. We try to get 3 in every show. We'll get to the third one on the other side of the break, so stick around for that and lots more coming up here. Ask a Lawyer on CP24. Coming right back.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Watching Ask a Lawyer here on CP24. So good to have you along this week. John Scholes here and Lior Samfiru, EmploymentLawyer.ca. Anytime to reach out, have that conversation with Lior, or he will set you up with a member of his team for sure. The phone number, 1-855-821-5800. 5900. Email works as well, ask@employmentlawyer.ca. And as I mentioned earlier, Lior, simply employmentlawyer.ca to find a radio station close to you where you can catch and call into our weekly radio shows, plural, all across the country, and join in the conversation. Right here in the GTA, that would be News Talk 1010 Sundays at 1 p.m. Phone call number 3, Lior, is coming right up now.
I work as a real estate agent, so I'm an independent contractor in that regard. I also am part of a team where most of my business comes from, so I'm employed by the head member of the team. And what happened was I've been there for 3 years, and everything was good. I always was told I was doing a great job. I noticed that the team wasn't being as successful as it could have been. It was starting to go down a little bit. Then I made one little blunder, and I was sent a termination notice. I responded saying, how come this happened? And the letter I got back was, well, we'll bring you back, but instead of a set salary, you'll be paid by the hour, and it works out to be 25% of what I was making before.
Wow, no, exactly. John is waving his finger then, and he's absolutely right. Not so fast. With real estate agents, I see this all the time, been seeing it for 20 plus years. In most cases, you're being misclassified as an independent contractor. You're really an employee. Very, very common with real estate agents. If you work for one company, you're almost always going to be considered to be an employee. Doesn't matter if you say you're a contractor, if you signed a piece of paper that says you're a contractor, if you're getting paid as a contractor. Why? Because if you look like an employee and act like an employee, hey, guess what? You are an employee. And that's important. It's important for many reasons. And in this particular situation, this call that we got from a radio show, because if he's owed severance, if he's an employee. So in this case, if he lost his job, unless he did something horrible, something terrible, he's going to be owed severance. And if he's offered back a position that's very different, a lot less pay, he doesn't have to accept it, and he's still owed his full severance. I want you to remember, if you're a real estate agent, a truck driver, whatever your position is, if you are supposedly a contractor, guess what? The law probably says you are an employee, and amongst other rights, you have the right to severance. So the question becomes, this real estate agent who was let go, contractor, company may think no severance. Well, I'm telling you, severance is owed. So let's go back to pocketemploymentlawyer.ca. Let's use our severance calculator tool, and let's just see how much severance this person is owed. So real estate agent, been there for 3 years. Company says no severance because you're an independent contractor. Well, you see there that he's owed up to 5 months of severance, and frankly, that's conservative. It could easily be 6 months as well. But right around 5, even 6 months of severance is how much he is owed. So for you at home, check out pocketemploymentlawyer.ca if you lost your job, if you're worried about losing your job, to find out how much severance you're owed. Of course, it's completely free, completely anonymous.
You can also reach out every week. In fact, we encourage you to join Lior and his team on the Facebook, YouTube, live streams as well. You'll want to join that. stlawyers.ca is how you join and have your say. Anyway, here's one for this week. Says, my boss wants to give me half of my work and my responsibilities to a coworker to lighten my load. I never asked for this change and, in fact, enjoy the work I do. Can I stop this from happening? Lior.
Well, the reality is that whatever the situation, you probably can't physically stop your employer from doing that. So if the question is, can I just make the company not do that? Well, you can ask, but you can't physically stop them. If they're going to do it, they're going to do it. The question is, do you have legal recourse if your company does take away your responsibilities? Well, here's the thing. It really does depend on what they're doing. If they're taking away half your job, they're keeping your pay the same, they're making your life a lot easier, yeah, that's probably something that they can do. On the other hand, if what they're doing reduces your pay or maybe makes it embarrassing, now you look like you've been demoted and your stature in the workplace has deteriorated because of it, well, that could easily be a constructive dismissal. That significant change can be a constructive dismissal, meaning you don't have to accept it. You can consider that to be a termination of your employment and get your full severance. And based on the usual factors, that could be as much as 24 months. Now, what I don't want anyone to do is just to quit, to say no to the offer to do anything of the sort without talking to me first, because we have to do this right. We have to make sure that we're enforcing your rights and we're not giving them up. So reach out if you're in that situation.
All right, Lior, we're humming along. I think we have time for another email on the other side of this short break. We will get to that and come back with more Ask a Lawyer here on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Okay, welcome back. Ask a Lawyer here on CP24. You want to reach out to Lior anytime. Phone call works just fine. 1-855-821-5900. Email, which we're about to go to, ask@EmploymentLawyer.ca. So here it is, Lior. We'll wrap up the show with this email. It says, I was just let go from my job for an unfair reason. Clearly a case of wrongful dismissal. I didn't even get the standard 2 weeks pay on the way out. I'm worried about this going on my ROE, my record of employment. What do you say, bud?
Well, John, there's a lot of assumptions built into that questions. You know what happens when you assume, and certainly you shouldn't assume anything when it comes to your workplace rights. So let's be clear. First of all, in terms of the reason, the company can let the person go for most reasons as long as severance is paid. But this person says, I didn't even get my standard 2 weeks. There's no such thing as standard 2 weeks. You're owed a lot more than that. Even if you worked for a short period of time, you're likely owed several months of severance. Doesn't matter if you work for a big company or a small company. So don't assume it's 2 weeks. Right off the bat, this is likely a wrongful dismissal because severance is owed. Now, with respect to the record of employment, that's not something you have to worry about. Record of employment is not really a record of employment. It doesn't impact your future employment. It's only relevant for the purpose of EI. We can negotiate with the company to make sure that's proper as well.
Yeah, there's no vault saying when you got let go from whatever job, right? Doesn't exist. Don't worry about it, right?
No big spreadsheet, no repository of these issues. You don't need to worry about that. That said, there's no reason we can't negotiate with your company to get you a proper record of employment so that you can get your severance and your EI. But the real issue here, the main important issue, is that of severance.
And with that, my friend, we are done. Thank you so much for tuning in and contributing to the show. You can always reach out now, 1-855-821-5900. That email address we use is ask@EmploymentLawyer.ca. And the website Lior mentioned a few times, we used it, pocket.EmploymentLawyer.ca, free anonymous access to the severance calculator. And then finally, the radio show. Join us right here locally in the GTA. That would be News Talk 1010, Sundays at 1 p.m. Thank you so much for joining us again this week. We'll catch you next week right here on Ask a Lawyer on CP24.